federal court of appeals just ruled that Texas can now deploy razor wire at the border. So then Texas sued. They said, hey, Border Patrol, stop cutting our wire. We now rule that Texas can have its injunction. I mean, the injunction is not barred by governmental immunity. We're not interfering with feds, but you're not securing the border, so we'll do it. Texas declares victory and the border states score a win. You can see Greg Abbott came out and says that a federal court of appeals just ruled that Texas can now deploy razor wire at the border. This is the same razor wire that the Biden-Harris people were cutting so that people could come on in. They wanted to deny illegal entry into the state. The Border Patrol were cutting the border fencing, and we'll read through the opinion. But if you recall, this happened some time ago. So this was the press release where this appeal went up. Now we got a ruling on it. November 30th, 2023, almost a year ago to the day, Ken Paxton appealed the decision that was from Joe Biden and Mayorkas that was allowing them to destroy Texas border barriers, right? You saw this, cutting the fencing so that people could just come on in. They were waving them in. So there was a lawsuit back and forth that took a year to develop. And now here is the ruling from the court. From the Fifth Circuit Court of Appeals, the state of Texas versus DHS, Homeland, and the Border Patrol. They write together as circuit judges in a major victory for border security, saying, together, we address whether the Border Patrol agents can legally cut a C-wire or concertina wire, we'll call it razor wire, the state of Texas has placed along the border. Border Patrol claims that removing the wire is sometimes necessary to fulfill its duty of patrolling the border to stop illegals from coming in. They have to cut the wire to prevent the entry of illegal aliens, sometimes though. The fence is located in the Eagle Pass area, which in the recent years has been the epicenter of unlawful entries into Texas. So then Texas sued. They said, hey, Border Patrol, stop cutting our wire. After days of testimony, the lower court agreed with Texas on the facts. They said not only was the Border Patrol unhampered by the wire, but its agents had breached the wire numerous times for no apparent purpose other than to allow migrants easier entrance inside. Okay, that's the only reason they cut it. Not like somebody's dying and bleeding out in the wire. Like, we got to save this dude. Okay, like, we don't want illegal aliens, but we also don't want like bodies floating in the Rio Grande either. All right, so like, that's not good. So, okay, we'll cut the wire to save this dude and then deport him back or whatever. All right, maybe that's your position. Maybe not. But you could say, okay, fine, cut it and put it back, put the wire back, but don't take the barriers down. That's what they were doing. Still, the court denied an injunction based on a legal point. They said, well, all this is true, but it believed that the United States retains immunity against Texas's claims. Okay, so yeah, Border Patrol are, a piece of work in this case, cutting the fencing so people can come in, but they can do it. Like, what? Federal government, what can we do? Now, a motions panel of our court disagreed and granted temporary injunction pending appeal. So then we said, no, actually, this is Texas. Okay, we have our own sovereignty, so we can keep our razor wire up if we want to. Then the United States appealed it to the Supreme Court based in part on events that occurred after the injunction. They claimed that in Texas's Shelby Park, 2 people drowned in the Rio Grande. The Supreme Court vacated the injunction without giving any reasons. So now our panel is now assigned to the appeal. We got remanded to find out what the heck happened in Shelby Park with those drowned immigrants. With admirable speed, the district court heard testimony and made new findings. Here's what happened. Texas's move into the park, it turned out, had only a marginal effect on Border Patrol's access, had nothing to do with the drownings. The case then returned to us and we heard oral argument at all. So Texas wasn't involved in that and the government was blaming them for those drownings. They had nothing to do with the drownings. We now rule that Texas can have its injunction, meaning Texas can tell the Border Patrol, stop cutting the fence. Specifically, the United States clearly waived sovereign immunity. Whoa, that's fun. As to Texas's state law claims. Love it. Says the conclusion is supported by a flood of uncontradicted circuit precedent to which the United States has no answer. And so they waived it. They're not immune. So they're not going to take take care of it, we'll take care of it. We also reject their alternate arguments. The injunction is not barred by governmental immunity because Texas is not seeking to regulate the Border Patrol in any way, only to safeguard Texas. That's all. We're not interfering with feds, but you're not securing the border, so we'll do it. Nor for similar reasons is the injunction barred by the Immigration and Nationality Act. And finally, Texas has satisfied the injunction factors. And more importantly, they say, the United States does not even contest that Texas has shown it will likely succeed on its state law trespass claim. And so they say, accordingly, we reverse and grant Texas a victory. Texas wins, and Border Patrol is hereby enjoined, which means stopped, limited, prohibited from damaging, destroying, or otherwise interfering with the C-wire fencing of Eagle Pass, as indicated by Texas. In instances where they have necessary access for emergency, the access must include the land side of the C-wire fence, so Border Patrol can have access to it, both sides, but they can't cut it. Great. Guys can go behind it, you can go in front of it if you want to, but you're leaving the fencing up. The wire remains. Here's a little bit more background. Along the 1,200 miles of the Rio Grande that forms the border between Texas and Mexico, there are 29 official points of entry. Now, in recent years, the number of Border Patrol encounters with migrants has swelled. It used to be 458,000 in 2020. Now, 2.4 million in 2022. Look at those numbers. That's an invasion. 500,000 to 2.5 million in 2 years. Federal numbers. This is what a federal judge, federal court of appeals put in their opinion. Now, exploiting this situation, drug cartels have made an incredibly lucrative enterprise out of trafficking people and drugs. In 2021, Texas launched Operation Lone Star to help the Border Patrol, but there's been a conflict in Eagle Pass. Maverick County and Eagle Pass are the epicenter of the current migrant influx. By September 23, Texas had installed 29 miles of C-wire in this area along several sections of riverfront, causing an effective deterrent, and an effective one at that, they say. Both Border Patrol and Texas agree the C-wire must be cut if there is a medical emergency. Okay, so even Texas is like, look, yeah, like somebody's like caught in there and drowning, like we'll cut it, we'll save them, but then they must go back. The problem arises when Border Patrol agents cut the wire without prior notification to Texas for other reasons. In fact, beginning around September 23, they began to clash in Eagle Pass. Agents from the federal government who are facilitating and co-conspiring to facilitate the invasion began cutting Texas's wire to permit aliens to enter illegally, sort of legally via their entrapment, right? It's like they're violating the law. They say they, I guess, have permission to do that, but the district court found that there were 14 incidents of wire cutting. A September 20th incident that was captured on video was the most illustrative. The video shows that Border Patrol agents have cut a hole in the C-wire to allow aliens to enter. They're Border Patrol. They then cut 2 additional holes about 15 feet away, and they install a climbing rope for migrants. Where's this video? Meanwhile, a Border Patrol boat passively observes a stream of migrants stretching across the river and onto the Mexican shore who were never interviewed, questioned as to citizenship, or in any way hindered in their progress into our country. Instead, after letting the aliens through, the Border Patrol sent them to walk as much as a mile or more with no supervision in hopes they would proceed to the nearest processing center. Literally cutting open the wall. Our own officials cutting open the wall. Due to repeated instances, Texas sued the so-called Border Patrol in federal court, saying, you're causing a first of all, you're damaging our property, you're violating the law, common law conversion, that's our wire that you just destroyed, and you're now trespassing on our efforts. Texas sought a preliminary injunction. 3 days later, a bunch of stuff was filed. Now, the court rejected as a factual matter that the Border Patrol cut the wire to inspect, apprehend, or process the aliens. They said, no, that's not why you cut the wire. It found that no aliens were inspected at all. I said, you just cut the wire to let them in. Like, don't tell us that. Regardless, though, Border Patrol agents could have inspected them without disturbing the wire because agents already have access to both sides of the fence. So there's no justification for cutting it. Just go around. Nor was wire cutting necessary to apprehend anybody. Indeed, no one was apprehended at all. Aliens coming through the holes in the fence that they cut in the video were waved along. They let 4,500 migrants in. The court rejected their claim that they were going to process them. They just let them go. The court also rejected the contention that wire cutting was needed to stop medical emergencies. Everybody here recognizes, yeah, look, if there's injuries, drowning, or dehydration or fatigue, yeah, it's real. Medical emergencies do justify justify cutting the fence. But those events would not justify any and all destruction of the wire. Ongoing medical emergency is an exigency that you need to address right then and there. But that's not what happened here. The court concluded that an emergency can be just as adequately addressed by less destructive means. Just go around, get them by boat. Don't open the fence. Pull them out of the fence. Don't have to cut open a fence because somebody's in it. Just pull them out from the other side. As to the Winters third and fourth prongs, they're met too. And they favored Texas at the lower courts. The lower court said you should have an injunction, but we can't because it's against the feds and they have immunity. So then it went up to the Court of Appeals and they had a battle over this. Went up to the Supreme Court, came back down. We had a limited remand. We're now back down in this court. First, the findings clarify that Texas's move into Shelby Park on January 10th created a 2.5-mile perimeter and an inner cordon within the park. You can see this in the maps right here. Big area. The findings also clarify that there was a boat ramp. Third, the findings shed light on the drownings. The court found that the emergency involving the drownings had concluded about 1 hour and a half before Border Patrol agents were there. Okay, so Border's like, we tried to save those people. We showed up, but the fence means that they had to die because Texas. No, they were dead for an hour and a half. Border Patrol agents arrived at the gates. By that time, Mexican officials had also rescued 2 other distressed aliens on their side. Finally, when Border Patrol approached Texas, the federal officers did not act as if any emergency were underway. They were just professional and calm. So there wasn't an exigency, an urgency. And finally, the findings addressed the broader contentions that they're an impediment to federal law. The court said, nope, that's way too vague. You can't say that you're at risk or being slowed down at all. Now, Texas says that the federal government waived sovereign immunity. They had the opportunity to secure the border, but they didn't. They point to the law saying that Texas has been adversely impacted by agency action. And when agency action is necessary to protect something and they fail, that's a waiver. 702 says a person suffering a legal wrong because of agency action who's adversely impacted is entitled to judicial review, which is what they're seeking now. The United States may be named as a defendant, and if they fail to act and they have the legal authority to act and they fail to do it, well, then they've waived their responsibility and we can step in to deal with it. Accordingly, that's what we're doing. Now, the district court thought that 702 was not plain enough, and they said, well, it's the federal government, okay? You can't really act against the federal government, and they give us their basis for that. But Texas's waiver argument is actually supported, they say. So the district court said that no, judges never want to find against the feds. So state is suing against the feds. The judge is like, yeah, like your argument is incredible, but it's still the feds. So like, no, sorry. But now the Court of Appeals is coming in and saying, well, actually, maybe, yeah. Says Texas's waiver argument is pretty dang strong. We've never suggested that 702 excludes state law or common claims like the lower court did. Every one of our sister circuits has said, yeah, sovereign immunity can be waived, even against the federal government. For instance, the Third Circuit talked about a New Jersey case. The Ninth Circuit has similarly talked about it. The 10th Circuit has talked about it. Now, the government fails to cite a single circuit where the 702 waiver applies only to federal claims. No, it applies to state claims too. So if the feds are not going to act on something and the state wants to come in and the Fed has a responsibility to act and they're not acting, and the state can say, well, okay, fine. Then you have waived your right to act. So we'll do it. One of their arguments merits a separate mention, talking about the FTC stuff, but let's fast forward through that. And to sum all of this up, 702 clearly waives the United States sovereignty immunity claim for the common law claims. The district court made a mistake in ruling otherwise, so Texas can act. And their claims are also not barred by intergovernmental immunity either. Texas is not trying to regulate anything. They're not imposing the state's will. They're acting in an area where the federal government has chosen not to. We're not targeting state laws. We're not targeting regulations. We're not applying laws to the feds. None of it fits here. Texas is not discriminating against the feds. All they're doing is seeking to enforce a generally applicable state law that prohibits trespass and conversion. That's all. And their right is embodied by Texas law. As numerous cases have recognized, we're not trying to control anything. So we're not inverting the supremacy concept. Texas is not saying we're more supreme than the feds. We're just saying the feds aren't acting, so now we can. The only duty implicated here is found in this law, which is the Border Patrol can control 25 miles within the border. But what we're suing for here is not to destroy our wire, and so that's incidental to your powers. They also suggest that it would create a conflict, but there's no conflict here, and it's also not preempted by the feds. So as we fast forward, let's look through and see if they summarize this for us here, saying that they believe Texas Texas will succeed on the merits. They say, first of all, concertina wire is state property. They've taken over that property by saying it's theirs and they cut it. So since it is their property, we can easily recognize that it is their property. Saying there's no immunity for you to destroy it, they'll succeed on this claim. It is their property and their property is being destroyed. Will there be irreparable harm? Yes, there will. Texas says it will suffer irreparable harm. It's a trespass. It's a risk of harm because people will come into the country. There's going to be a decrease in public safety. There's going to be more crimes and drugs entering Texas. And so the Texas court said that there would be irreparable harm, but again, that the feds were immune from any action to stop them from causing that harm. And so they said the court discredited the government's justifications for cutting Texas and their wire, describing their conduct as culpable and duplicitous, the lower court said, labeling their arguments as cynical, not crediting their evasive answers and demeanor. The lower court blasted them. You're harming Texas bad, but you're allowed to do it, and so I can't stop you. Accordingly, the court concluded that compensation for past injury cannot adequately redress this, and so this does cause irreparable harm. So they say, yeah, there's no clear error here. We'd only reverse that if there was clear error, but there isn't that we've identified, so yeah, they win that. And last, we turn to balancing equities and public interest. Texas contends that Border Patrol is doing deserves an injunction. They say we agree in part. First, there is generally no public interest in the perpetuation of an unlawful agency action. The court found that the federal government exceeded their authority by cutting the Texas wire, and because they exceeded their authority, this withstands review. Now, second, the vast swath of private and state land where border can enter gives them a ton of land, and so they can do that. So we balance these equities. We disagree that a well-crafted injunction would have the effects of risking human life. Okay, feds can do what they need to do. Texas can do what they need to do. It's not going to be causing this insane damage that, Border Patrol is saying exists. As to risks for human life, this factor is neutral. Texas's C-wire does conceivably pose a risk to human safety, but so does the defendant's behavior. So does Border Patrol. The court found that they facilitated and they encouraged aliens to undertake the dangerous task of crossing the river. They're incentivizing them to come across, causing them to be put in harm's way, causing them to walk inland into the United States miles on their own, trafficking people across the border. They are human traffickers. The Border Patrol agents who are cutting these people in are facilitating human traffickers. They are co-conspirators. They are responsible for 300,000 missing kids that nobody knows where they are by cutting these fences and letting them in. It found that the very emergencies that they assert make it necessary to cut the wires are of their own creation. The unauthorized port of entry at dangerous stretches of the rivers causes immigrants to have life-threatening crises. And the court found that the C-wire is a deterrent, and an effective one at that. So that doesn't favor anybody. And finally, we reject the government's contention that Texas's fencing undermines international relationships, okay? Mexico's complaints focuses principally on the buoys in the Rio Grande, but the buoy issue was never raised in this litigation. And our en banc court recently vacated an injunction against the buoys, moving the buoys to the American Bank, saying would ease international relations. Now, similarly, Border Patrol here have not shown how removing the wire on Texas's side would help international relations. True, both of Mexico's complaints reference the C-wire, but they suggest the main problem is the C-wire in the floodplain. That is not at issue. The C-wire here is on top of the riverbank, not in the floodplain. Now, more importantly, though, concerns about international relations do not erase property owners' rights over thousands of their land. Who cares what Mexico says? Our precedents, old and new, make clear that concerns of national security and foreign relations do not warrant abdication of the judicial role. And foreign policy below, the binding level of a treaty or legislation doesn't displace Texas law, and so we find no error there. And so in conclusion on this, Texas's state law claims for injunctive relief are not barred by governmental immunity, and so we reverse and grant Texas's request for an injunction. Stop cutting the fences. Hereby, moving forward, federal government goons are hereby enjoined from damaging, destroying, or otherwise interfering with Texas's C-wire fencing in Eagle Pass. And as indicated in Texas's complaint, in instances where federal agents have the necessary access, they can use that access. The necessary access must include the land side of the fencing and the international border ports within Shelby Park. So the fence is here. They cannot cut the fence, but the Border Patrol can come in this side and in this side and access both sides. No problem at all. Have fun. Enjoy it. Do your little laps up and down, but don't you dare cut that fence. You people should be building a fence, securing the fence, not cutting it, and being co-conspirators in a human trafficking operation that's resulted in 300,000 missing kids. Sick, sick people who are claiming that they are securing the border when in reality, they're not.